Hello everyone, my name is Lalit Tony and you are watching Polity This Week by Drishti IAS. In this episode, we'll be discussing certain topics from polity which has been in news in the past week, and these topics will be important for your examination. So let's start with the discussion. So we'll be seeing 4 to 5 topics today. The topics are related to fun, that is Clause 6 of Assam Accord. Assam Accord was in news recently because for the implementation of Clause 6 there was this committee which has given its report long back, and now the government is trying to go for implementation of nearly 52 recommendations of this committee. Okay, so in that regard, this particular Clause 6 of Assam Accord was in news, so we'll be discussing Clause 6 as well as what is Assam Accord. Then moving further, we'll be talking about the witness protection scheme. Then we'll talk about the POCSO Act. Okay, when we talk about the POCSO Act, you know that is you can say an act which is for the safeguarding the interest of children against the sexual offenses, etc. So we'll be talking about that. Recently, Supreme Court has actually given a constructive definition or the constructive you can say interpretation of word, that is possession of child pornography. Okay, so we'll be talking about that. Then Armed Forces Special Power Act, or you can also say AFSPA. Okay, so that was there in news with respect to the context of Manipur. Okay, so we'll be talking about that, and then in the end there will be an topic which is related to the provision for scheduled tribe. Okay, because there was recently a scheme which has been launched for the, you can say, scheduled tribe communities. So we'll be talking about this particular provisions which are safeguarding the interest of scheduled tribes. Okay, so before moving further, we'll be having this announcement that at our different centers at Lucknow, Prayagraj, Jaipur, Karol Bagh and Indore, we are having this GS Foundation course for prelims as well as mains in the offline mode, and it will be available in the English medium. So you can directly visit the centers and get enrolled in this particular courses, or if you can directly call on this number, that is 8010440440 for any kind of queries. Okay, again the number is 8010440440. Different courses are starting on different dates. Lucknow, it is starting on 16th of October, Prayagraj 3rd of October, Jaipur 7th October, Karol Bagh 17th October, and Indore the course has started. Admissions are open, so you can visit the centers and get enrolled. Okay, so let's start with the discussion. We'll be starting with the first one, that is basically Clause 6 of Assam Accord. Now, you know that after the independence, and then after, you know that there was this issue of Bangladeshi immigrants in this particular region. When we talk about the formation of Bangladesh in 1971, there was a huge scale of migration which has happened, and in that particular migration wave, there are many people who has came from Bangladesh to India. Okay, in that regard, there was this you can say some kind of concerns in the minds of the local Assamese people, that these people who are coming from outside, they will have a competition for the resources which are available to them. Considering that there were you can say protests which has started, and then for after like 6 years of protest, there was this accord which was signed between 3 parties. Okay, so the accord was signed between the government of India. At that point of time, Prime Minister was Rajiv Gandhi. Okay, here you can see in this picture there is Rajiv Gandhi which is sitting over here, and then second party was state government of Assam, and the third party from the sides of Assam movement was basically all Assam Student Union. Okay, so this was the prominent parties in Assam Accord. That accord was signed in 1985. Okay, and that in that particular accord there was certain special privileges has been given to the Assamese people, and for that privileges we have this Clause 6. Okay, now for the implementation they have gone for a formation of a committee. We'll be talking about that. So here you can see, when we talk about the Assam Accord, here you can see Assam Accord was signed in 1985 to end the agitation against the Bangladeshi migrants. It was a tripartite accord which we have already seen, the government of Assam, the government of India, and the Assam movement that has been represented by the All Assam Student Union in 1985. The signing of the accord led to the conclusion of 6 years agitation that was launched by All Assam Student Union in 1979, demanding the identification and the deportation of the illegal immigrants from Assam. For that, they have set up a date, that is 24th March 1971. Now they have said that between 1951 to 1971, those people who has came to India, that was the cutoff date, they will be citizen of India but they will not be having voting rights as of now. They will not be having certain rights as of now for like some particular years, and afterwards they will be getting these rights. Those who has came after 1971, these people will be considered as you can say migrants, and they will be their cases will be given to the foreigners tribunal. Okay, so that was the thing which has been discussed in the Assam Accord. Now however, the demand was for the detection and the deportation of the migrants who had illegally entered Assam after 1951. That was the demand, but accord was signed, and the benchmark, you can say the date was decided, cutoff date was decided as 24th March 1971. Okay. Now this is the Assam Accord. Now what does the clause 6 of the accord says? So here you can say, it says the constitutional, legislative and the administrative safeguards as may be appropriate shall be provided to protect, preserve and promote the cultural, social, linguistic identity and the heritage of the Assamese people. Now they have said that these are certain benefits which will be given to the Assamese people. Here you can say constitutional, legislative, administrative safeguards will be provided with respect to protect, preserve and promote culture, social, linguistic identity and the heritage of the Assamese people. Okay. So here problem was, who are these Assamese people? How will you decide that who is Assamese people? For that they have actually gone for creation of a committee. Okay, and that committee was under the High Court Judge Biplav Kumar Sharma. Okay, Biplav Kumar Sharma has given its report in 2020. When we talk about the creation of this, you can say committee, that was in 2019. Okay, July 2019, Home Ministry has created this committee, and they have given this report to the state government of Assam. Okay, they have given this report to state government of Assam, and now the government is saying that they will be going for the implementation of the recommendations. There are total, you can say 67 recommendations has been given, out of which 40 are to the state government. These are, you know, in the jurisdiction of the state government. There were other, you can say 12 which are having center and state angle to it. Okay, so and the other 15, okay, other 15 are basically there which are related to, you can say, center exclusively. So right now they are saying that they will be going for implementation of these 52 recommendations, and then these 15 will be considered for the center's consideration. Okay, so that is the you can say news right now. Okay, now when we talk about this committee which was chaired by Biplav Kumar Sharma, they have given the definition of the Assamese people over here, and they have actually said that there are certain safeguards which should be there. We will be talking about these recommendations now. Now key recommendations are related to one, land. Second was related to your, you can say, culture, and third was language. These are some prominent recommendations which were given, which we will be discussing. First is land safeguard. So basically a special revenue circle will be created. Only Assamese people who can own and the transfer the land. Okay, so in this particular area now Assamese can only own and transfer the land. Second thing is land titles. There are people who are living here you know, on certain lands for like, you know, more than a decade now. Now these people will be given the land titles. Okay, they are living there, they have the possession, but they do not have the title. So these people will be given the title if they are Assamese people. Okay, then third is river erosion affected people. There are people who are affected by the river erosions or the because of the floods in this particular area. Now these people will be given a government land for the settlement. Okay, so these are the recommendations related to the land. Then when we talk about the language, there are three recommendations were given. One is Assamese will be the official language, and for the local areas where other languages are there, so there you can use the local languages in the specified areas like Barak Valley, Hill District and the Bodoland. Okay, so now here you can say Assamese will be the official language, and in the you know, other areas, selected areas, local languages can be used. Now government acts, all the government or the state governments acts and orders, rules, they will be there in Assamese as well as English. Okay, alongside English, earlier there was only English, alongside English there will be Assamese as well. Then Assamese in schools, so they will make it mandatory in the schools of CBSE etc. that till class 8th or 10th there will be, you can say, Assamese, which is compulsory. Now cultural heritage, so they have said that satras will be established. So neo-Vaishnavized monasteries, these satras are, when we talk about the establishment, you must remember there was this Saint Shankar Deva. Okay, he was the person who has started this neo Vaishnavite movement in Assam, and their monasteries are called as satras. Okay, so for them, they have set the establishment of an autonomous authority for the development of satras, including the financial assistance. Other than that, there should be cultural complexes which should be created to enhance the heritage, or you can say to provide some kind of upliftment to the heritage of the Assam. So this is about the safeguards which has been discussed. There are certain safeguards which the recommendations are there which will not be implemented as of now. These are 15 sensitive recommendations on the lines of reservation, inner line permit, etc., and they are under the center's prerogative, so they are kept for the, you can say, discussion with the center. One is inner line permit, that is similar to the, you can say, Manipur. When we have Manipur also has the inner line permit system, etc. So on similar lines there should be inner line permit system. Then 80 to 100% reservation for Assamese people in the parliament and assembly, in local bodies and the government job. Since it is a matter of reservation, again center will have a say in this. Creation of upper house in Assam, fully reserved for the Assamese people. Now for that also they will require a note from the center. Okay, so this is the issue with respect to the clause 6 of the Assam Accord. We have seen what is Assam Accord, we have seen what is clause 6, and we have seen what kind of recommendations are there. Okay, now we can move to the next one that is related to the you can say these are the issue involved. Okay, but we have already discussed this, so you don't have to worry about that. Now we'll be talking about the next thing, that is witness protection scheme. Now recently Supreme Court has talked about witness protection scheme. There was this scheme which was started in 2018, but Supreme Court says that it is not fully implemented yet, so there are gaps in implementation. Okay, and for that Supreme Court has said that we now need a full-fledged law for that. Okay, so now right now we will be talking about the witness protection scheme. We will be seeing some assets of that, or you can say characteristics of that. Supreme Court concerns key facts about the witness protection scheme 2018. So that we will be discussing. Recent Supreme Court observation, concerns over the ineffective implementation which was there, highlighting the needs for the dedicated witness protection law. Okay, so issue is ineffective implementation. Okay, development and the legal framework. First ever scheme by the Ministry of Home Affairs approved by the Supreme Court to protect witness from threats and intimidation. Now when we talk about the witnesses are basically eyes and ears of justice. Okay, so their protection is very much important. Because of these threats, intimidations, all these things might actually be an obstruction for a witness to come into court. Okay, so in that regard Supreme Court says that there should be this particular scheme. Okay, and then Home Ministry has come up with the scheme. There are, you can say, witnesses which are classified in 3 categories. One are the witnesses which are receiving the life-threatening danger. Okay, if a witness is witnessing, or you can say getting a threat that is life threatening, in that case he will be put into category A. Then when we talk about the threat to safety and reputation, then he will be in the category B. And in the third, moderate threat and harassment, in that case he or she will be in the category C. Okay, they have not categorically you can say defined the word witness over here, but they have said that court can summon anyone for who is essential for the case. Such person will be witness. Okay, now aims and objective, so obviously it is for the protection of the people who has been summoned by the court, or they are witness of a particular act. Okay, now moving further, if we talk about the protection measures, so what kind of protection measures are there with respect to that scheme? So here you can say changing identity, relocation, security devices, face-to-face contact prevention, in-camera trials, safe courtroom based on the threat perception. Okay, so these are certain things which the, you can say, authorities will do, that like changing the name of the witness, or you can say relocation of the witness to a safe place, or security devices to be installed, face-to-face you can say interaction should be avoided with the accused. Okay, so all these things are there. Then state witness protection fund. Now for all these activities there will be a fund which will be created, and from which there will be all these you can say expenditure will be done. Okay, and how will you actually have this particular fund, or you can say money in this particular fund? So that can be from the allocations, states allocations, fines, donations, corporate social responsibility contributions, etc. Now endorsement by the Supreme Court, Mahendra Chawla case 2018, directed scheme implementation across all states and union territories under Article 141 and 142. Now Article 141 is saying that Supreme Court is a court of record, so Supreme Court's order are you can say valid all across India. Second is Article 142, that is whenever necessary Supreme Court can go for giving any kind of direction in the interest of justice. Okay, so these are certain things which are there with respect to the this protection scheme. Now why do we need a dedicated law for the witness protection? Because when we talk about the international standards, there are countries which are already having it. Okay, so that is one thing. Second is importance of witness protection. Witness are crucial for justice. Absence of legal protection affects their willingness to cooperate. Okay, if they are not given the legal protection, then they might not appear in the court because of the fears, etc. Okay, then moving further, Supreme Court and the committee recommendation, there are various cases wherein Supreme Court has said that we need a dedicated law. One is Anirudh Singh 1997, Zahira Sheikh case 2004. In that case, Supreme Court has said this thing. Malimat Committee, when we talk about the reforms, etc. in the criminal justice system, Malimat Committee has actually said that there should be witness protection law. Other than that, also when we talk about the law commissions, etc., 154, 178, 198 law commission has actually talked about this. Okay, so this is about the witness protection. Okay, now we can move to the next one, that is basically your protection of children from sexual offenses, POCSO Act, that is 2012. Now, with the name, it is clear that it is to prevent child from the sexual offenses or any kind of harassment. Okay, now since children are more vulnerable, they do not have this you can say capacity to understand what is going on with them, so that make it more sensitive topic. Okay, so that is why there is this dedicated law for that. Now age cutoff for this particular act is 18 years. Anyone who is below 18 years will be considered as children. Okay, now let's talk about the issue right now. So recently it was in news because the Supreme Court has talked about the issues of child pornography. Okay, and in that regard, they have expanded the definition of the word possession. They have said that not only having the physical, you can say, data with yourself, that is possession obviously. Other than that also, if you are having a constructive possession, okay, that you has watched it online but you did not download it. So right now you don't have the possession but you have watched it online. In that case also it will be considered possession. Other than that, they have said that if you have this on your device and you did not report it, let's say some anonymous mail has come and you did check the mail and you found that there was this child pornography which was there in the content and you did not report the case. In that case also you will be liable. Okay, so these has been discussed in the Supreme Court, so that is why we will be talking about this particular you can say law. Now POCSO Act was enacted to protect children, defined anyone as who is under age of 18 years from sexual exploitation and abuse. It came into force following India's ratification of the UN Convention on the Rights of the Child in 1992. Okay, so this convention is there, so you can remember that. Now what are the key features? So this particular law is gender neutral. Okay, be it a guy or a girl in that case, or if the kid is boy or a girl, in that case the POCSO will be there. Okay, so that means that it is protecting both boys as well as girls, so there is no discrimination on the basis of the gender. Okay, so that is there. Now confidentiality, so there is this section 23 which is saying that identity of the child victim must be remaining confidential. Even the media house, etc., they cannot reveal it. Okay, moving further, mandatory reporting. Section 19 to 22 are talking about the mandatory reporting. If you have any idea or any kind of you can say you have any kind of doubt with respect to that or any kind of knowledge with respect to that, in that case you have to report the case to the police. Okay, so that is the you can say key characteristics of this particular act. Now moving further, if we talk about the gaps in the implementation, so there is lack of the support person. Now when we talk about kids are very sensitive, so you have to make sure that there are special arrangements should be done so that kid could feel comfortable over here. Okay, so for that you will require the support person, etc. In India we have dearth of the support person. Okay, 96% of the POCSO cases lack support person who assist victims through the legal process. A support person can be individual or the organization specializing in the child rights and the protection. Then insufficient POCSO courts. We don't have dedicated POCSO courts as well. All over India we are having 408 case you can say courts only. Then shortage of the special public prosecutors, so that is also issue of the manpowers. We do not have the public prosecutors for the cases. Okay, so these are the gaps in the implementation. Right now if we talk about the Supreme Court judgment, I have actually made a summary over here for you. You can go through this. Otherwise we have already discussed what is constructive possession. Okay, so in the constructive possession court has said that an individual can be considered to possess child pornography even if they do not have physical possession of it but have control and knowledge of the content. Okay, so that is also one thing. Second thing is, if we talk about the you can say certain things here when we talk about the storage, etc. So one more thing Supreme Court over here he said that if someone is mailing you okay, in that particular mail there is this content which is a child pornography, or you can say a material which is there, which is violating a child privacy, etc. So in that case, if you has opened it and you realize that this is child pornography and then you did not report, then also you will be liable. Okay, so that has been observed by the Supreme Court recently. Okay, so you can go through this particular content which we have already discussed in the starting. Now moving further to the next one, that is talking about the Armed Forces Special Power Act. Okay, when we talk about the Armed Forces Special Power Act, most of the time you must have heard that whenever there is a situation of law and order, we always discuss that there should be deployment of the special forces. Recently in Manipur, you know that violence has been going on for like 1.5 years now. Considering that there are talks with respect to the AFSPA, but right now it is not been, you can say, deployed as of now. Okay, so we'll be discussing what are the special powers which are there with the AFSPA. Now when we talk about this act, this is a British era act. Okay, so British colonial government implemented the Armed Forces Special Powers Ordinance on 15th of August 1942 to deal with the Quit India movement. Okay, so that is there. After independence, the Armed Forces Bill was passed by the both houses of the parliament and was approved by the president on the 11th September 1958, and then it has become an act. Now why did we, when we talk about the British era, they did it to suppress a particular movement? Why do we need it? Okay, why did we go for the implementation of this particular act? We were a nascent state. Okay, so after that 1956 we have gone for the reorganization, etc., and then there were various demands of other states as well. Considering that since we were nascent state, we wanted to make sure that unity and integrity of India is not threatened, and for that this particular act was you can say implemented. Other than that, to deal with the issues of law and order, that was the main objective. Okay, so that was the objective of Armed Forces Special Power Act. Now when we talk about the provisions, what are the provisions here? You can say under the AFSPA law, in a disturbed area, the Central Armed Police Force deployed having unlimited powers to kill any person violating the law. Now here we are talking about the powers. One is unlimited power to kill. If there is a suspicion, okay, that a person is violating the law, in that case also you can go for killing a person. Okay, so that kind of power it has been given in this particular act. Then moving further, arrest without a warrant and conduct searches. Now basically they are curtailing the civil liberties. Okay, so that is there. Then the law ensures immunity from prosecution and the legal proceedings without approval of the central government. Any person or the, you can say, officer which is under the deployed under the AFSPA and he has done a particular act while performing a duty, he will not be prosecuted until unless the central government gives permission for that. Okay, so that is a special power which is there. Both state and central government can issue notification regarding the imposition of AFSPA. So that is certain provisions which are there. Now there are pros and cons, as we have seen when we are talking about the pros. So basically here we are saying that if something is challenging the unity and the integrity of the country, then it can be useful to deploy the you can say special forces over there. AFSPA grants the necessary legal authority to security forces to handle the insurgency and the terrorism effectively. Okay, provide legal protection to the security personnel, that is one thing. While performing the duty, he is immune. Boost the morale of the armed forces. These are certain positives. When we talk about the negatives here, you can say violate the autonomy of the states. Now center has the power to deploy AFSPA in a particular area. So in that case, when we talk about the law and order is a subject which is given under the statelets. Okay, but if AFSPA is implemented, in that case the, you can say, power goes to the you can say security forces. Okay, the excessive use of force which is there, that authority to shoot without permission. Okay, so that is excessive use of force. Other than that, infringement of the civil liberties. As I told you, there will be arrest without warrants. Okay, so they are curtailing the civil liberties. Lack of accountability, since they are protected, they are having this immunity unless there is a, you can say, order from the center to go for the prosecution. So the persons or the officers under the AFSPA deployment, they are basically you can say immune. So that is why you can say that they are having less accountability. Okay, so these are pros and cons with respect to the AFSPA. Now we can move further to the next one, that is talking about the Pradhan Mantri Janjatiya Unnat Gram Abhiyan, PMJUGA. Okay, so when we are talking about this particular you can say scheme over here, so we will be talking about the census, etc. We will try to understand the situation of ST community or the scheduled tribes. Okay, 2011, that was the last census which has happened. After that, census was due in 2021, but because of COVID, it has been postponed. And recently, it was said by our, you can say, Home Minister that they will be going for the census soon. Okay. With respect to the 2011 census, India has scheduled tribe population that is 10.42 crore, that is 8.6% of the total population, consisting of nearly 705 tribe communities. Okay, so we can say that in India we are having more than 700 tribal communities. Okay. Pradhan Mantri Janjatiya Unnat Gram Abhiyan for improving the socio-economic condition of the tribal communities. Then when we talk about the, you can say 705 tribes, we are having certain particularly vulnerable tribes. We are having, you can say 75 PVTGs, particularly vulnerable tribal groups. Okay, for them there is this another scheme, that is PM Janman. Okay, we have already discussed that in our news analysis, etc. Now, it is a centrally sponsored scheme for the welfare of the tribal families in the tribal majority villages and the aspirational districts. It envisions the fulfilling critical gaps in the social infrastructure like health, education, livelihood through the different scheme of the government of India by the convergence and the outreach. Okay, so that is the idea, that we are trying to give certain safeguards, certain, you can say, help to the tribal communities so that they can be part of the mainstream society, or they can get the essential services. Okay. Now, moving further, here we will be talking about certain provisions. Here we have already seen that it is 8.6% of the total population, and there are more than 700 tribal groups which are there, which has been notified under Article 342 of the Indian Constitution. The power is with the President to notify, and if there is a change in the list that has to be done, that will be done by the Parliament. Okay. Then Article 342 of the Indian Constitution outlines the procedure for specifying scheduled tribes, which is there. So this article becomes important. Article 275 of the Indian Constitution guarantees the grant in aid from the Consolidated Fund of India each year for promoting the welfare of the scheduled tribes. So that is also important. When we talk about PVTGs, as I told you, there are particularly vulnerable tribal groups which are there in India. We have 75, and maximum are there in Odisha. Okay. Bhil is the largest tribal group which is there in India. Okay. And Madhya Pradesh has the largest population of tribal community. Okay. So that is there. Now, there are other safeguards like Article 15, Clause 4, Article 15, 16. These are basically talking about the advancement of the other backward classes, including the STs. Then Article 29, that is talking about the protection of the interest of minority. They also include the STs. Okay. Coming to the Article 46, that is a DPSP, which is there for the promotion of, you can say, special care. Okay. So here you can say state shall promote with special care the educational and the economic interest of the weaker section of the people, and in particular of the scheduled caste and the scheduled tribe, and shall protect them from the social injustice and all form of exploitation. Okay, so that is Article 46. Coming to Article 350, that is the right to conserve distinct language, script and the culture, which is there in Article 350. Article 330 is talking about the reservation of the seats in the Lok Sabha for the scheduled tribe community. When we talk about Article 332, that is talking about the reservation of seats in the state legislature, and Article 243 is talking about the reservation of seats in the panchayat. Okay, so that is, these are the provisions which are there in the Constitution with respect to the safeguard of safeguarding the interest of the scheduled tribe. Okay, so these are the topics which we have already discussed. We have discussed 5 topics. Now there will be 5 questions for you. Okay, so there will be a test. I'll be reading out the questions and you have to answer to me in the comment box. Okay. Now coming to the first question over here, which date was set as the cutoff date for detecting illegal foreigners in Assam according to Assam Accord? 1st January 1951, 24th March 1971, 15th August 1947, 26th January 1950. Okay, so this is a very simple question. Moving further, question number 2. Which of the following committees recommended the establishment of the formal witness protection law in India? Malimat Committee, Sarkaria Commission, Narsiman Committee and Kelkar Committee. Okay. So you can attempt and answer in the comment box. Question number 3. According to POCSO Act, the child is defined as a person who is below age 16 years, 17 years, 18 years or 19 years. Okay. Question number 4. Which of the following is true about the legal immunities under AFSPA? Armed forces personnel can be prosecuted without any approval. They have no immunity from prosecution. Option C is they are immune from prosecution and the legal proceedings without the approval of the central government. D, immunity is granted only by the state government. Okay. Now the last question, question number 5. Under which article of the Indian Constitution are scheduled tribe notified? Article 275, Article 342, Article 370 or Article 356. Okay. So you can attempt all these questions and answer to me in the comment box. Okay. With that, I would like to take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.